The title of the paper I prepared back home was Social Stability and Equal Protection of Conscience. I then saw the program here, and I saw that it would at the most have 13 minutes. That paper would take half an hour. I cannot be cured as an optimist. So I rewrote the thing. The paper I'm going to read to you and present to you has 4 titles. I want to focus on that. Subtitles. First, freedom of religion or belief, the language of human rights, international human rights, has an extremely wide scope, and I want to stress that. That's the first point. Second point, I want to address something you may have heard of, the Golden Rule. My third title is the American legal tradition of religious freedom protection, where I see wonderful things and some problems. And the last one, very short, equal protection of conscience, 2 challenges. And those 2 challenges are the main thing I'd like to discuss. Here we go. So, having been given this very important topic, I initially thought my question would be like this. Can, by a right, a country's legal protection of conscientious claims of people who are religious, can they exceed its legal protection of conscientious claims of people who are not religious? And does such differential treatment or protection have an impact on social stability? Question mark. In other words, how disruptive, if at all, of social order is discrimination between protection of claims grounded in serious religious conviction, on the one hand, and on the other hand, protection of claims grounded in serious non-religious conviction? Same question. Well, having thought about this for some weeks and seen the title and the schedule we have now, I decided to drop entirely saying anything about social stability in the abstract. Instead, I shall discuss the normative issue of the law favoring protection of religious people's conscience over protection of non-religious people's conscience. That's what I want to focus on. And what strikes me, I admit I'm a Norwegian, what strikes me is that the law favoring protection of conscience grounded in religious conviction over and above protection of conscience grounded in non-religious conviction simply is unfair. Such discrimination is, I shall argue, even whatever you think, is prohibited by international recognized human rights law. And it is in breach, moreover, of straightforward religious morality, the morality of the Golden Rule. Do unto others as they, So let me first spell out the human rights principle I have in mind and then indicate my understanding of the Golden Rule through the 2 first headings I mentioned. The wide scope of religion or belief. Now, the term in English, religion or belief, used in international law of human rights after 1945, includes religion as traditionally demarcated. But religion or belief also includes non-religious fundamental convictions. Moreover, people who identify neither in terms of their religion nor in terms of their non-religious conviction, they are similarly covered by international human rights law. The religious, the so-called non-religious, and the indifferent. The point of such inclusive reference is that no human being is to be excluded from the human rights protection prescribed by what for short is called the right to religious freedom. The point I'm making is spelled out in the authoritative 1993 General Comment number 22 of the United Nations Human Rights Committee, which was addressing the right to freedom of thought, conscience, and religion. Article 18 of the Declaration. And the text of this general comment at this point runs as follows, I quote, Article 18 of the International Covenant on Civil and Political Rights protects theistic, non-theistic, and atheistic beliefs, as well as the right not to profess any religion or belief. End of quote. That's the authoritative elucidation. And similarly, the European Court of Human Rights, in its 1993 landmark decision, Kokkinakis versus Greek, states, and I quote again, the European Court, as enshrined in Article 9 of the European Convention on Human Rights, freedom of thought, conscience, and religion is one of the foundations of a democratic society within the meaning of the Convention. It is, in its religious dimension, one of the most vital elements that go to make up the identity of believers and their conception of life. But it is also a precious asset for atheists, agnostics, skeptics, and the unconcerned. End of quote. So the same inclusive notion of the human right to freedom of religion or belief was spelled out in this room exactly 2 years ago today by no other than Professor François Tilken, who is formerly a judge and vice president of the European Court of Human Rights. And you can have the reference. It was printed in Brigham Young University Law Review. I shall now add a brief note on the language used in Article 18 of the Universal Declaration of Human Rights, and later on, in the provision, Article 18, which is the provision protecting freedom of religion or belief. And my comment is this: the English term or belief should not be understood to include solely religious belief. The point is to include for protection also freedom of basic non-religious convictions. Life stances, as we say in Norway when we try to speak English, or German, Weltanschauungen, such as skepticism or atheist doctrines or indifference to matter of religion or life stance. This is clearly indicated by the term убеждение. I hope my Russian is here, which is used in the Russian original proposal for the language of Article 18 back in 1947-8. The better French translation is conviction and not croyance or foi. Conviction, not belief. The terminology may be confusing, and in what remains of this short presentation, I shall sometimes use the term religion so as to refer to convictions and adherence of the religious in a traditional sense, as well as to convictions and adherence of traditionally non-religious people. Let me now turn to the relevant and well-known rule of religious morality that I have in mind, the Golden Rule. As you know, the Golden Rule is found with small variations in the scriptures of almost all religious traditions. In the Gospel, Matthew chapter 7, verse 12, and similarly in Luke 6, verse 31, Jesus is reaffirming what Rabbi Hillel the Elder, referring to Leviticus chapter 19, verse 18, had taught 1 or 2 generations earlier. And I quote from the Gospel of Matthew, "So in everything, do to others what you would have them do to you, for this sums up the law and the prophets." End of quote. Question: does the Golden Rule apply to how religious people who are citizens of a contemporary democracy should deal with their others, with the non-religious citizens, concerning the legal protection of their respective freedom of religion or belief, in the meaning that I spelled out? Does the golden rule apply to how the secular law of religiously diverse polities today should regulate matters of freedom of religion or belief between different religious and non-religious groups and individuals? Myself, as confessed, a Norwegian Lutheran, I can have very little doubt. Since I come from a country that only recently have ended centuries of hegemonic and privileged state church status for the evangelical Lutheran religion and its adherents, to the disadvantage of all others in the realm, be they of other religions or non-religious or whatever. So in my view, the golden rule most certainly applies to legal regulation of the relationship between religious majorities and religious minorities. Next little item, the American legal tradition on religious freedom protection. The most important and rich national legal tradition on planet Earth, in my view, in the field of protection of religious liberty is that of the United States. When the Universal Declaration of Human Rights was elaborated in 1947-48, American NGO and religious activists, among them the later famous John Foster Dulles and Frederick Nolde, I'm proud to say he was a Lutheran from Pittsburgh, no, from Pennsylvania. These Americans effectively lobbied for strong and clear-cut protection of religious liberty in the language of the Declaration. They were very successful, perhaps too much so. For there's a problem here. Madison's famous memorial and remonstrance, the First Amendment to the US Constitution, and later Supreme Court uses of the ministerial exception seem to me to have triggered a theist reading of religion and exclude a reading of religious liberty such that agnostics or atheists or skeptics or scientific rationalists, etc., they are not excluded for protection on par with the theists. Am I wrong? Am I wrong? Am I right? I would like to hear from you. As I have argued at some length earlier, legal protection of freedom of religion or belief must accommodate today the legitimate diversity of differing religions and worldviews in contemporary America, and cannot no longer exclude legitimately protection of the conscientious commitment of human beings who are not religious. And now I come to the last point, equal protection of conscience. Two challenges. There are many more, but the two I want to focus on are these. Number one, can we, put as a question, can we who are religious in the traditional meaning of the word, can we still justify privileged legal protection of our beliefs, our faith-based practices, our institutions, over and above similar protection for humanists, for atheists, for skeptics, for non-religious rationalists? I tend to think the answer is no. No longer can we do that, in my view. Of course, we must be mindful of the distinction between the matters of so-called forum internum and matters of forum externum. Now, US jurisprudence and the European Court of Human Rights jurisprudence have found reasonable but somewhat similar ways of restricting legitimate interventions in the practices and institutions grounded on faith, in faith or in conviction. I shall not address this very complex issue now. But here's my last challenge. My first was, can we stick to this privilege as religious people for our affairs, for our institutions, for our practices? I gave you my answer. And the last challenge I want to address in concluding these short remarks, I hope they are short enough, is an extremely laudable legislative compromise found in this state of Utah in the middle of March this year, SB 296 and 297. It was a compromise, legislative compromise, between parties whom we are used to identify as belligerent antagonists in the American culture war. traditional faith groups versus gay right groups. The piece of democratic state legislation in Utah in March this year does not at all satisfy the maximalist demands of the LDS Church here, nor the maximalist demands of the LGBT groups. That's not the point. The point is that they did not satisfy the maximalist demands. The point is that, and what is so remarkable, is that this compromise, I will not go into details to say a little, it was acceptable to both parties nevertheless, because, and insofar as, I would add, the compromise regulates access, in the case, to housing and to employment in a manner that both parties have worked out through dialogue, through negotiations, through mutual respectful conversations, premised on the need for practicing civility across deep divides that are not to be eliminated, at least not soon. My congratulations to the state of Utah. Utah is, in my view, a model, not necessary in the specific legislative outcome of political compromise, but in the exercise across deep divides of mutually respectful civility. My congratulations.